I have been super excited about this interview because it's so controversial. It's about the voice of the child. And today I am welcoming Nilaja Ford. Here she is. And she is in New Jersey. New Jersey. I was just in New Jersey last weekend. We were at a party, but we love going to New Jersey to eat ice cream anyway. All right, so let's see if we can get her on. Oh, beautifully.
Wonderful. Yeah.
Yeah. So it sounds like, Nilaja, you're one of the unicorn attorneys because you have the background in domestic violence, which of course is so necessary for many of the people, all of our clients and many people in this community. So I love that this perspective comes from, this interview comes from that perspective, someone who truly does understand that. And we're going to be talking about who knows what, but especially the voice of the child in terms of custody and coercive control. I think I told you that our recent book just came out a couple of months ago. It's called When Your Ex Turns the Kids Against You. And there's a lot of strong feelings about the voice of the child, especially for people who feel that their child has been influenced. So we'll talk about that too. But before we even get into it, Nilaja, why don't you tell people who you are and a little bit about your background?
Sure. So Nilaja Ford, I am a co-founding partner of Ford Brown Law, which is my law firm, along with my partner Donnett Brown, who also is a specialist in domestic violence and family law, as well as criminal. We both were prosecutors at one point for the state of New Jersey. So I actually was a prosecutor who handled DV contempts and things of that nature, even then, but then transitioned to just being solo exclusive family practice with matrimonial, custody, and domestic violence matters.
Okay, awesome. All right, so one thing that we see often come out in these custody battles is something called hearsay. Can you just explain what hearsay is? Because I think a lot of people don't understand.
Without taking everybody to law school, anything that is not said in the courtroom, meaning someone's testifying to the judge that's present, able to confront both of the parties, cannot technically come in or be introduced as evidence. So it's an evidence rule. And so that goes back to our constitutional rights to be able to confront our accusers or to confront statements about us or things of that nature. So in this, if we're talking about, say, child custody, for example, a lot of times people will say, well, can I have somebody write a character letter or, talk about that? And yes, at the time of a motion, people can submit sworn statements from other individuals at the motion. But if we get to a hearing, technically that person needs to be on call to recount what they're saying about whatever the topic is, to be so that it actually can be used as a proof in the hearing, and for the judge to consider. So this also goes to clinician records. So if the kids are in therapy or one of the parties are in therapy, yes, your doctor can submit a letter. That's great, but technically they need to be on call to talk to the judge, which sometimes is a lot of conflict because mental health professionals try to avoid court as much as possible, especially because of all of the confidentiality and, the things of that nature. But what ends up happening is that we utilize experts a ton, so custody experts, but they're brought in to the case and knowing that they're going to submit some type of report. However, they also are supposed to be kind of on hand so that it can be questioned. How did you arrive to this conclusion? How did you, gather this information? Because all of it is questionable under, the rules of evidence and authentication.
By both sides.
By both sides. And the judge, doesn't matter if the judge is going to have questions. Now I'll just reiterate, I'm a New Jersey attorney, so I'm speaking informed about New Jersey practices primarily, but a lot of this stuff is kind of across the board in states that do follow more progressive rules when it comes to child custody and things of that nature. So hearsay, again, remember, it's simple, but it's not simple. I can't say, oh, well, the therapist told me da-da-da-da-da. That's hearsay. The therapist has to be there to say it for themselves, right?
Yeah.
If the therapist is there, then again, we're talking to the therapist about it. We don't have to relay secondhand information.
Yeah. And I made that mistake years ago where I was like, oh, my daughter's therapist wrote a letter and the judge said, I
Can't
can't
consider
accept
it.
that because anybody could have written that. I don't,
Correct.
and I understood that. And we often have to tell our clients the same thing because they're like, I'm going to get the teachers to write letters. I'll get the doctors. But you can't use that. Right.
Correct. Correct. So that's exactly it. And it's a different thing if, say, everybody in court is utilizing the same expert, or we're all going to utilize. I mean, if the school can put a record, or there's a ton of hearsay rule exceptions. Again, gets into the more nitty gritty, but the bottom line is, unless it's like a regular report, say in a report card. I use report cards all the time because we're looking at attendance, right? So that's a document that they're using in the regular course of business that we're introducing, that we know it's all, that's the system says your child was there or not, or your child was tardy or not, right? So that's something that we would, the courts will consider, especially at a motion stage, right? Because we're giving them we don't use the word probable cause in family court, but we're giving them enough on its face to say, okay, there's something going on here, or possibly.
Yeah. Now, in custody situations, especially with domestic violence, there's a lot of hearsay with kids. What can you tell us a little more about what you see, maybe mistakes that people make in terms of how they present or what they do wrong?
Sure. So I guess the one thing that I will say about the new custody statute, it is meant to clarify a lot of those things, because children, we know, will say one thing to one parent, one thing to another parent, because they're trying to appease both. Right? So what happens now that, they've nicknamed this children in charge, the way they've revised the statute, because their voices are now going to be heard. And the court is not necessarily acting as a guardian ad litem, but the court is hearing the information from the direct source, right? So a lot of the times we do know that kids are saying maybe multiple things, or not even, maybe don't even have the language to flesh through what they feel. So with children's interviews, and I think I mentioned to you previously that I've been doing them before the statute got revised, and I'm heavy-handed with them because they were always a part of the statute. What the child's preference was. That was always one of those 14 factors. So New Jersey has the best interest of the child standard. There's 14 factors. That is still the standard. The amendment or the revisions have come into play more so how to do this in the court. How do we just take a sheet of 14 factors? The judge just gets to say, okay, these are the 14 factors, and makes a choice, right? So I've always pushed for child interviews because our judges are trained to do them and do them efficiently, right? So they're trained to do them in a way that we're not putting a child in the witness stand booth. They may sit at a table together. The judge may not even have their robe on. Yes, it's being recorded as a court recording, but they are recordings that are under protective order. So, parents, if they are going to listen or utilize that information, it's not to be like disseminated on Facebook or to say, oh my gosh, they were, it's for the child to be able to speak freely away from both of the parents and directly to the person who makes the decision.
Yeah. So with that, I have all kinds of questions, like age. So if I have a 4-year-old saying I want to live with one person now.
The age is always going to go to the weight of this. So, for example, and I was wondering if people call, is it going to interrupt? But I can just silence. So apologize if you see me like reaching for a button. It's the decline.
Yeah.
But children, again, when they have language, technically they can be interviewed. But of course, too young, we're not going to get very much. So the questions, again, come from the parties. We get to submit as a party, plaintiff, defendant, mom, dad, whomever. We get to submit questions. And the goal of that is to really get down to the bottom of what information are we trying to get from, say, a 4-year-old. Of course, as they get older, the weight goes up, right? Because there's more autonomy, there's more they're thinking about their lifestyle or their, relationship with both parents or their friendships. And we have this a lot in like relocation cases. So for those of us who do heavy relocation practices, the child's voice is a big weight, right? Because if we're saying, I want to move you across the country, but you say, hey, well, my best friend is here, my grandma is here, my cousins are here, that's something that's going to weigh heavily on a child's decision, whether or not the parents feel like it's in that child's best interest. So it's more so letting them have a space to have a feeling or have a concern. How much weight it's given after the interview is still up to the discretion of the courts, but it's pulling in all of this information. So we say 14 factors, one of which is what the child's preference is. We still have to consider history of domestic violence. We still have to consider, can each parent financially take care of the child? Is their home life stable? Does the schedule even work? We have people who work overnight shift, right? So what does that look like? So there's a lot of factors, and it forces the court to literally utilize case by case facts as opposed to a one, cookie cutter, model fits all, because we know that's not the case. And when you throw in domestic violence in the mix, we now have concerns about, okay, when was this abuse reported? What was the nature of relationship when everybody was intact? What were those dynamics? And we as legal professionals are not clinicians, right? We can't jump into that territory by making assumptions. So if we say, hey, our child, since parent A left the home, the child is experiencing difficulties, right? We can't make any diagnoses of what those difficulties are beyond saying, absolutely, we're all having a hard time with this transition in our family. But when we start to see concerns where, if there was abuse in the home, parent A, and I'm saying parent A, parent B, because I represent men and women that are victims of domestic violence. I represent men and women who are perpetrators possibly, or, accused of domestic violence. So I want to keep it neutral. And I have same-sex parents. I have the whole gamut, right? So I want to keep it neutral. But a lot of the times during breakups, and then not to minimize leaving an abusive relationship or anything else, the opinion of the romantic relationship or the parent to parent relationship has deteriorated, in an impossible way. So one thing that I often do is tell my clients, separate that relationship with how you're parenting or possibly going to co-parent and what your child needs from that person that has nothing to do with you.
Yeah,
right?
that's very
And that's
hard.
the hardest piece. But once you understand that piece, you understand why the courts say best interest of the child, not parent A, not parent B, not grandparents, not girlfriends, boyfriends, not new husbands, new wives. It's about the child's best interest, and taking yourself out of that and your feelings out of that is the most crucial piece, but of course the hardest piece, because especially if you've been through a relationship that has had domestic violence or any other toxicity, I see that person as my opposition. You know what I mean? That's the adversary. I don't want to get along. I don't want to agree. I don't want to compromise because of what I've been through. Oftentimes the children have been a witness to this or have seen it, or, even if it's just the arguments, even if it wasn't physical violence, how dad talks to me, I don't like, or how he talks to mom, I don't like. A child may have an opinion about that. But we also have to be clear to not go into the area of differences of parenting style, because that's another nuanced conversation. Bedtime at mom's house is 7:30. Bedtime at dad's house is 8:30. Is anybody wrong there? Not necessarily, right? And we would have to go into the reasons why it should be 7 versus 8:30. And that's a very minuscule example, but think about that on the grand scheme of things, right? That would be considered a parenting decision, not something that's going to, show custody parenting time. If you tell me the child's not going to bed on time and they're late every day, we go back to that record, that attendance record. Now we have to say, okay, well, why are they late every day? And it's almost like the court, that would be a parenting decision that a court would jump into, because now it's affecting the child's school record, not just what I want to see happen in my household. So that's going to be the always the kind of same formula to get to these conclusions. Is it a difference in parenting style, or is it actually going to affect or harm the child? And harm for the child is the standard.
Mm-hmm. Yeah. So I'm thinking about school, their health, their extracurriculars, and maybe religion, like those major areas of legal decision making.
Mm-hmm. Those are the biggies. And that legal decision making is always presumed to be 50-50. Always in the state of New Jersey. That's where we start. If you're going to do anything different, you're going based on that start point. Why now can those major decisions not be made in tandem? What are the reasons why you can't come together on which school, what doctor, because that's all we're really asking, just to be considered or notified in the decision. Not that everybody's going to agree on every single thing, but then now the reasons why. And when we get into the actual time, like, I saw some of the comments like, oh, well, he got 50-50 or she got 50-50. That's a parenting time decision. And that's also based on the best interest of the child. And it really goes back to those 14 factors. So the first thing I say when people call me and say, I need sole custody, I want sole custody, my first question is why? Tell me, what are the things that are happening that makes you want to be the sole legal parent, right? Because we start there. And if you tell me because he brings him late to school, or, he doesn't show, or he or she doesn't show up, or, that's a different conversation than sole custody. It's okay, when he's not there or she's not there, what happens? I have to make the choice by myself. And the courts allow you to do that, right? So or they are impossible. They won't say yes to anything. They won't let me do anything, or they disagree just to spite me. Give me an example, right? Because now we can address that specific issue through the courts. Doesn't necessarily mean sole custody, but it does mean that issue gets addressed because that issue affects the child, or there's a possible place for harm for the child. So
okay, so here's a common one.
Sure.
So I want sole custody because my ex is abusive. They've been abusive to our child.
And what I would say is and my next question is, tell me how, right? And if it's definitive, hey, I have a final restraining order, because I think I mentioned to you, restraining orders in New Jersey do not expire. They're final for life.
Yeah.
And even with that being said, we make people co-parent. Okay. So the final restraining order took care of the domestic violence between you and that other party. If the children were involved in any type of abuse, most states have child protective services. They should have been the ones involved to handle any abusive contact between any parent and child.
So getting a third party, not just me saying there's corporal punishment, my child is scared to go with the other parent.
Correct. If you haven't called, we have DCP&P here. If you haven't reached out to them to investigate, to do anything like that, I'm going to tell you that's your first step, right? Anybody can call with any allegation of abuse, because that's exactly what the division is there for, right? But even with that, they're going to investigate, was it a pop on the hand one time? Was it, I beat this kid with a electric, cord, extension cord? There are levels to what constitutes abuse. And I've had plenty of orders. We say no corporal punishment of any kind, right? You can get that ordered because, of course, it's not in the child's best interest to be punished that way. And again, abusive conduct towards the child, if as a parent, I did not report it, right? I also have a place, an accountability place. But now, even if that occurred in the past, the court is going to weigh the incidents and the relationship between the parent and that child, right? If it was, oh, they got a pop on the hand, we're not going to see much of a difference. If the child was locked in a closet, we're going to see, okay, you're not going to be around the child, because DCP&P or the division is going to tell you, you are not fit. You are an abusive parent. So that it's a different body that needs to investigate and get involved. And the courts, I've seen judges say, okay, well, so he's been doing this forever. Not that we're blaming anybody, you've allowed this or because we've had moms who have been extremely mentally abusive, right? During the course of a marriage, during the course of parenting, they have their own issues, right? So they would have to follow recommendations, anger management, batterers intervention, all of the things through the courts as someone who is now considered an abuser, either of the other parent or of the children. And that's the route. And that's the route that's supported, because they're going to see if there's any findings or not. Not just what our opinion is of abuse, but definitively, is this something that's founded or unfounded? And then there's levels to those decisions as well.
Yeah, and thanks for explaining that, because I think that is very hard for people to grasp.
Yeah. Or know that you can have your feelings, but they have to be kind of not validated, but they have to still be investigated, right?
Mm-hmm.
And that person should not be you, right? I don't need to. You're the person that reports. You're not the investigative body per se, and they make recommendations for therapy. They make recommendations for all types of things for the children and the other parents, because their job is to try to keep families intact, even if they need help to do so.
Yeah. And that's another very strong message that we have to keep telling people that they don't want to hear. So speaking of that, with the children in charge, what is actually going to be different? So say, what's different from how it was? Because I know that some people are celebrating, and some people, many people that we work with, whose exes have used the kids as a weapon to pick sides of who they want to be with, are very, very scared. Tell us a little bit more about that.
So the changes have come due to concerns with domestic violence issues and the safety of the children. So this revision is not necessarily, like I said, it's not a new statute. It's revised to give clarity and give more protections to the children in terms of their safety. So, for example, we're talking about corporal punishment, right? If that's occurring, we've had investigations. We still are going to hear from that child, right? We just like DCP&P or your Child Protective Services is going to interview the child. The judge also gets that right to hear it firsthand. And now, they might have talked to, say, like I said, the protective service workers and have made their reports. The worker is going to have a whole, documentation of what they've done with this family, what they've talked about. And those documents can go directly to the court, because it's still part of this governing, bodies and agencies. That's who the courts will send out if there are issues, right? But the judge still is the ultimate one who's going to make the determination.
Yeah.
So it comes from Caden's law, which has been, other states, but there was a child who died, right? Because we're not hearing what this child's preference, or I don't want to go there. And sometimes it sounds like I don't want to go there. We're not hearing a why. Or, so we're trying to get to those whys again. That's like the most important piece, so that we can make sure children are not getting hurt or abused.
Yeah. And I'm glad you say that, because I feel like there's a fear about just listening to a child's voice without looking at the broader context. So in terms of the child's voice, how much is it like a once-off conversation? The reason I'm asking is because we have men and women, many, many clients who have teenagers who have been turned against them, who have aligned with one parent, and they're still minors. And our clients really want to have the opportunity to reconcile on some level, or get some kind of family therapy or anything before the child turns 18 and they're out of the system. And they're really worried that, and we've already seen decisions made. Just yesterday, one of our clients in a different state a judge said, well, even though one of the parents wasn't following the parenting plan and basically just took the kid, and the kid was 14 at the time and just never came back, and the kid expressed that, they still love their other parent, but the judge thought, well, why should we do reunification therapy at this point? Because the kid is 16 and our client is beside themselves about it. And the kid also had ambivalence, saying, I still love that parent. And so an order was made saying, well, the kid gets to decide and everything. And it's like, what do I do as a parent when a kid's been conditioned for a while to choose that parent? They've lived with them primarily. They can't go against that parent. And now nothing's going to change.
So again, even in those cases, those parents, they're not in New Jersey, so I can't, speak to that. But in our state, it's illegal to just move your kid, no matter what age they are. you have to do it appropriately, which is bringing it before the court if you don't have the permission from the other parent. And I've had people that have gotten felony charges because they've done it. New Jersey does not play around when it comes to that.
No, they really don't.
Okay, they
Those
do not.
lifetime restraining orders. Oh my gosh. I don't know any other states that have that.
Yeah. And I mean, again, what I do love about the state, they take domestic violence in any form or abuse in any form very seriously. And a lot of these rules, though it's making people anxious and scared, it's literally on the back of like Violence Against Women Act and how the kids are used and affected through the abusive process. The hard part for me is when they are teenagers, because it is correct that the weight of that conversation gets heavier. It's going to weigh, it's going to give more weight to that conversation. But also, I unfortunately know and have seen that people sometimes none of this happens overnight, right? So if you've been abused, if you've been in these situations and now you have gone or you've taken the children and gone, again, talking to someone before making just decisions is going to be key. And then the other piece is understanding that the courts are looking at best interest of the child, meaning it's going to cause the least amount of shakeup in that child's life.
So consistency
is big and it's key. So, when I represent parents who the child has been taken from them, right? If what you were given or what you were agreed to was saying doing summers versus like that, the time on paper may be almost exactly equal. It just doesn't look the same because we're not in the same place, right? But ensuring that you do have the time, even if it's state to state parenting and the relationship, phones and video. I mean, we're on FaceTime right now. We have never seen each other a day in each other's lives, but we have now formed a relationship. That is still a big thing. Technology has gone a long way with just being able to have a relationship. And most teenagers have friends that they've never met across the globe, gaming and all in the life. So relationship is really what it's going to fall down to. And if you're saying, hey, this person's been having this child against me, all of these years, it's kind of tough to jump into the court process with this history that's already been established for so long. Same thing that I tell my folks that have had a hint of domestic violence. Say something immediately. And that's also a hard thing to tell people. But in terms of dealing with the courts, the timeliness in the reporting is your biggest, that documentation is your biggest ally, asset, everything else. If now at the time of the breakup, this person is horrible and everything, and I've never seen any indication that, you've done anything else to try to help this child up until this point or try to change that relationship up to this point, and now we're going to the court to say, end it, we have to back up, and that's unfortunate to hear too. Acts and omissions do count against you in the court of law.
Acts and omissions is good.
So that's the tough part.
Yeah. So speaking of that, almost parallel with a child, let's say there's been a relationship with a child that was fine up until the split. And then suddenly the child is saying, I don't want anything to do with
it. And that would be one of those areas where we're saying, why? Again, the question is always going to be why, right? And now if we're hearing from the teenager, well, even though we were all together in the same house, I never liked the way parent A or parent B conducted themselves, right? Whatever. It made me feel bad one way or the other, whether it was actual abuse or just verbal or just emotional criticizing, the pressure, the whatever the case may be. We also do know that teenagers are teenagers. And, if mom didn't let me go to the party, but dad always says I can go, who do I like more? And so it's not sometimes a heart deep, a deep, like, I hate this person, they're the bane of my existence. It's more like parent A is a drag, it's cooler.
They're annoying.
It's annoying, and they're old enough to kind of, everything's annoying. I have a teenager, it's like everything's annoying, but at the same time, we have to get to those deeper issues. And a judge is going to say, well, tell me why I usually put the question on for my list for the children. Tell me what the ideal custody situation will look like for you. How much time would you spend one place or one place? Give me specifics, because those specifics are going to be the tells. You know, if I love being at dad's house because he's closer to my favorite Wawa or he's closer to my friend, you know what I mean? Because, you know, all you hear is, I want to be at dad's or I want to be at mom's, right? You don't, we want the whys. Give me the whys, because now as the adults in the court, we can make, you know, assessments on, all right, well, they're just saying this because of that, or they're saying like, this person is a terror in the house. They're a menace and I don't want to be around the drama or people that are fighting or whatever the case may be.
Yeah. So we said there's people that think, a lot of people think this is wonderful, this new, you know, some of these clarifications. But then you had mentioned that there's a lot of professionals who don't think this is wonderful. Why not?
I'm using the word old school, not because they're older people, but just more traditional approaches. So the traditional approach is keeping kids out of the courtroom. Okay. Or keeping children not involved in the process. And my counter is, they already are. So when I explain it like that to people, who are like, oh, you know, we're going to ruin these kids. We're going to have them these kids are already in therapy. They're already on social media. They're already seeing relationship dynamics that children of the past, I would say, didn't see. I saw a post recently that said, because us as adults are on social media, our children, or not just our children, but people get to see us behaving as adults, not necessarily as that phrase in the house where this is the adult, this is what the rules are. And we're seeing they're seeing other adults behave in the wild, right? Which is very different from when we grow up. If anything, we had like Full House. We knew, you know, Dan Tanner and the kids, and we knew Family Manners, like we knew the Urkel families and all that kind of stuff. We didn't see what parents were like when they were being petty, when they were being spiteful, when they were being immature, you know, which happens a lot. So it's a little bit different. And I think our children are exposed to a wealth of things that children of the past were not. So I've had my kind of, my child can't wait to get in there, right?
Oh, yeah.
Because they have their own gripes about probably both parents, you know? And we've had guardian ad litems for years, right? And that's more so someone else, that's another third party, comes in and that they represent the child. We used to only give children a voice like that when we thought the case was so high conflict or, you know, things of that nature. But imagine the families that can't afford to hire a gal, you know, or a guardian.
Most people, I mean, it's so expensive and it takes months or sometimes a year.
And custody evaluations usually start at like 8 to 10K, right? So access to the courts is a big thing for New Jersey. If for simpler issues, because I mean, a guardian ad litem still may be, you know, assigned or things of that, custody evaluation still may have to happen. But if we can have this in a conversation where mom and dad have both answered all 14 of these factors, which oftentimes parties do not do. And then they're like, why did I get my custody decision? You didn't address what the court standard was, right? But now the children get to come in and are basically able to speak as to what they feel is in their best interest or makes them happy. And unfortunately, parent A and parent B have to kind of hear that information. And then again, what are the whys? You know, the judge is always going to ask, did anyone tell you what to say today? Does anybody talk to you about the court cases? Because we have the New Jersey Children's Bill of Rights that most people oftentimes are in violation of on both sides, just because, you know, if I've been hurt, I can't help to be on the phone with my girlfriends about, oh my gosh, I can't believe he did this. If your children are in earshot, that's not, you know, great for the child.
Right. We say eye shot because even if they can't hear, they see your body language and they know what you're talking about.
Exactly. And that goes for the person who everybody, you know, unfortunately, there's always going to be two sides to everything. And what the courts are trying to do is get to the middle, the truth, like what's going to be still best for this child, knowing what I know. I have gotten sole custody decisions before. I have gotten people back their custody before. I have been able to make people relocate. I have made people stay here. I do all 360, right? So there's almost nothing you can tell me that I'm going to be like, oh my gosh, I've never heard this before, you know? some days I get shocked at the behaviors or how they play out, but it's still the same thing over and over again. And I think a
Mhm.
lot of people feel like, oh my gosh, this is not fair to me, not understanding that there's a world of professionals that have gotten to make these revisions, amendments, updates, because we're trying to help a specific issue. Again, child safety. Like, it has nothing to do with parent A or parent B, except for how their behaviors affect that child, right?
Yeah.
Um, and that's the tough part too. When my client, and I've said this to my own clients, they'll say, "Well, that's not fair," and I said, "Well, like, I don't, I can understand that. I can feel for you for that, but I would have to take you back to the beginning when you first met that other parent, right? And
Mhm.
how things have transpired along the way." And I think that's what you were mentioning before. We wanted to have that conversation because it really does start at the beginning, unfortunately, and recalling again those acts or omissions that have gotten us here today, and then now what to do with them. And if it's less of a hard thing on the child versus one of the parents is not going to necessarily like it, that's usually the best thing. So like I said, if the decision says, why aren't you letting this person see their child 50% of the time? What is the why? And those whys don't stack up, you're going to think, oh my gosh, this judge just, doesn't care or da 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 da. And if someone is being withheld by the court in that time, that person's going to think, oh my gosh, like, this is not fair to me. I'm a parent. I have my rights. It puts the children's rights above the parents' rights. And that's what they mean by children in charge, because they're almost harmless typically in the situation. So someone has to advocate for what's in their best interest.
And their lives are what's affected the most. I mean, they're the ones who now
Absolutely.
have to move back and forth.
I always say in a perfect, I mean, I'm a co-parent. I've been co-parenting since my son was 2 years old, right? I've never seen the inside of a courtroom. And I mean, again, I would have not maybe left the relationship. It wasn't not a relationship that I wanted to leave. So there are some issues there that were happening between parent A and parent B, but we both literally love each other more than we hate or not. I mean, there never was like even like a hate aspect, maybe at first, but like
Hmm.
we've grown to the point where what we need for our child, we're going to be a team united like Voltron, no matter what happened. Even if I have my boundaries now and I have my restrict or whatever the case may be, that's a me and you conversation, not a me, you, and our child,
Mhm.
conversation. So if we're thinking legal custody is a big decision, I mean, yes, I may not want to talk to the other person about anything, but if we can get to what school they should go to, or we need this specialist, or should we get this surgery or not? Those are questions that have nothing to do with the relationship. And I've had courts say, if you don't hear from the other parent within 24 hours, you make the choice. I've had that put into orders,
Yeah,
you know, because so then somebody can't stonewall the other.
exactly. Yeah, we
That's
should
the
have a whole
difference.
other conversation about parenting plans.
Right,
How
right.
they-
But again, I love the statute. Like I said, I've been doing it this way since before they revised it because I find value in it. And I think it also puts into perspective what children are feeling outside of what we're feeling about the situation as a whole.
Yeah, that makes sense. And
Mhm.
then just quickly, and thanks for taking all this
Oh,
time.
no.
You said that most of the time, what kids say they want both parents, and that can actually be helpful to a parent who's been sort of cut out. Can you
Hmm.
tell us why it is helpful? Because I think people think, oh no, they're not going to say they want to be with me.
Right. So the children only know what they know. For example, if say the breakup happens when the child is like 4 or something like that, very young, they've only known maybe dad on the weekends, or something like that. So if dad is now coming back or mom is coming back to get more time, we have to have like some type of change in circumstance. One of the changes in circumstance can be the maturation or the work schedule change or whatever these things are that brings you back into the door. We're not trying to take a child away from another parent, right? It's just increasing time. In circumstances where a child has been kept from the other parent for whatever reason, the child has been given the benefit by law to have both parents in their lives, right? And they only know what they've been exposed to. They may have never seen all of this bad treatment that parent A is talking about or complaining about, right? So it's like, okay, I did this to protect my child first, but the court is saying, hey, that should have been done kind of through us, not just your choice to be
Mhm.
you're not the judge in that scenario.
Yeah.
So one of the things that I always say again is just to hear the information and get to the whys.
Yeah. You
And
know,
the
that's
organ
the title of this interview, Getting to the Whys. I was
get
like, I
to the
got it.
whys.
Give me
Yeah,
the whys.
give me the whys. And that's what I'm going to push you to do if I'm representing you. Walk
Mhm.
me through. I want to hear all. I want to hear, oh, he cheated with that person, or she left me from above. I want to hear the whole thing because it's going to inform how you're all focused or how you all can move forward with the co-parenting relationship if you can,
Mhm.
right?
Mhm.
And
Yeah.
and it's not the child's position or responsibility to mend a broken romantic relationship.
Yeah.
That's what I say about it's not about us as the parent at all, because that's something different. But will that broken relationship inform how I communicate or work with the other person? Absolutely. So, like, let's problem solve. I always get people who want to focus on the problem. Okay, so what if we fix that? Then what?
Mhm.
If we fix this or if it looks like this, and that goes back to the custody parenting time plans, things of that nature, because they do have to be tailor made to a degree.
Yeah.
But the cool part is that when kids talk and they say, oh, no, I don't want to stay with parent A or parent B, they're horrible to me. That's a big deal. Whereas before, it just being on those list of 14 factors, if you're not calling in the kid, parent A is going to say whatever they want, parent B is going to say whatever they want, because technically that is a hearsay issue, right?
Yeah.
And no one has heard from this child. And I think it's cool that I've seen in situations where we have inhibited, I have one right now that's ongoing with the mom. She's the one that's the abusive parent.
Mhm.
And the child said, listen, I love spending time with my mother until she starts talking about my dad.
Yeah.
I love when I'm spending time and hanging out with my cousins until they're chit-chatting about how my new family or, not a new family, but like, maybe somebody's being remarried. They're looking for things
Mhm. Mhm.
to pick apart as opposed to just spending time with your child. That's the purpose. It's not, you don't spend time with your child just to, have a case against the other parent, So it goes really deep, but that's like a surface level of a way to put why this new revision is important and does matter,
Yeah. I mean,
Thank
I'm
you so
hearing
much.
it like from my English teacher background as you get a primary source now. You go right to the,
Right to the source, right to the
and it
source.
can save money from doing all of these evaluations.
Court trips, money, you name it, right? Like it's so key. Said access to the courts, getting this evaluation, getting this somebody else to take a look in to your situation, because we never can recall everything 100%, right? Unless you are just the most humble person in the
Mhm.
world, right? I can say what my role was, what their role, and oftentimes that still needs to be relayed to the court
Mhm.
directly.
Yeah.
Let that
Yeah.
person make that decision.
Yeah. Well, thank you so much for this, Nilaja. Can you tell people how to find you?
Well, you can find us online at fordbrownlaw.com. We do the full state of New Jersey, my partner and I. And then again, we also, I think I mentioned to you, run a legal services clinic at Shani Baraka Women's Resources Center in Newark, New Jersey with Mayor Raz Baraka. So we do also give free legal services, more in terms of consultation and things of that nature, but they can reach out to Shani if there are any domestic violence particular needs. And we do free consults, so just find us on the web, and we're always down to have the conversation.
Amazing. Okay, and everyone's going to be jumping on.
I know.
So, like, what about other states? Can we call you from other states and other countries?
Right. Well, in terms of coaching, sure, but not for legal, because technically we only practice here for now. But yeah, but I'm always down to have the conversation because I think it's helpful just to
Yeah.
process.
Oh, wow. Well, thank you so much. I'm so glad to finally see your face.
I know. Thank you so much for having me. And like I said, keep in touch.
We definitely will. All right. Take care.
Take care.
Bye.
Bye-bye.